A testator could have changed his mind sometime before the execution of his will with respect to devices given out in his will, or as regards any beneficiary. So what this is saying is that there are situations whereby the testator, before signing the will, may have changed his mind about who is going to be my beneficiary, who is going to be his beneficiary, and to what extent will he be a beneficiary. Now, what this will mean is that this will necessarily bring about some changes in the will naturally, and that for such to be valid, the testator must make a memorandum and execute the same. So, summary of what I'm saying here under this alteration is that an alteration is an act done to any instrument after its execution, whereby its meaning or language is changed, whereby its meaning or whereby the meaning or the language of the alteration is changed. Sorry, of the instrument is changed. But it is possible that the testator could have changed his mind sometimes even before the execution of his will. Before the execution of his will, with respect to devices, bequests to be given out in his will, or with regards to who will be the beneficiary. And that what this means is that it will bring about some changes in the will. And for such changes that are made before the will is executed to be valid, the testator must make a memorandum and execute same in that will. Now, let us look at provision of section 14 of the Wills Act of Lagos State and section 16 of the Wills Law of Lagos State. Of course, this provision of this section 14 of Wills Law of Lagos State and then section 16 of Wills Law of Lagos State, they are similar. They both make provision with respect to any alteration in any will. Please listen, and I'll read out to you what this provision provides for. It says, no obliteration, interlineation, alteration made in any will after the execution thereof shall be valid or have any effect, except insofar as the words or effect of the will before such alteration shall not be apparent, unless such alteration shall be executed in the like manner as is hereinafter, as in herein before required for the execution of the will. Now, it goes further to say that provided that the will with such alteration as part thereof shall be deemed to be duly executed if the signature of the testator and the subscription of the witness be made in the margin or some other part of the will opposite or near such alteration, or at the foot or end or opposite to the memorandum referring to such alteration and written at the end or some part of the will. What this section is saying in summary is that you are not expected to alter your will after the will has been duly executed. But if you must alter your will after the execution, if you must alter the will after the execution, then you are supposed to, you are supposed to conform with the formalities of will regarding execution with regard to that alteration. That alteration must be initial or must be signed by you, and the witnesses must also sign. You could do that by the margin or somewhere close to that alteration in the body of that will. You could also do that, signature, or put your signature to validate that, that alteration at the bottom or at the foot of your will. If you have not done any of these, if you have not done any of these steps required to be done by Wills Act, when you have actually altered your will after it has been executed, then that means that alteration will not be valid. That alteration will not be valid. The gift that you are trying to make by virtue of that alteration will be void. It will not be given probate. I'm not sure whether I'm making any point. Are we together? Are we together?
Yes, sir.
Class. Okay. 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 Now, let me also mention to you that from the foregoing provisions, some issues become very apposite. Some issues become apposite. That is, alteration must be made. What that means that alteration must be made before the execution of the will. Alteration must be made before the execution of the will. So where this is the case, the alteration will be valid, and these are section 14 of Which Law of Lagos State and section 16 of Which Law of Oyo State will not be applicable. They will not be applicable. Now, the alteration must be duly executed. Where this is ensured, then alteration is valid. Now, alteration means that part of the will is no longer apparent. So, from this, provision of section 14 of the Which Law of Lagos State and section 16 of Which Law of Oyo State, we are saying that the following three issues become apposite. One of them is that alteration must have been made before the execution of the will. Where this is the case, the alteration will be valid, and this section 14 of Which Law of Lagos State and section 16 of the Which Law of Oyo State will not be applicable to that alteration. Now, note also that the alteration must be duly executed where this is ensured. And where this is ensured, the alteration will become valid. Note that part of will that is altered must no longer be apparent. Those three issues are important for us to take note of them. Now, we now look at alteration made before the execution of a will. Now, an alteration made in a will before the will is executed by the testator is said to be valid if the testator intends the alteration to form part of the will when it is executed. Please note, and I repeat myself, that alteration made in a will before the will is executed by the testator is valid if the testator intends that the alteration should form part of his will when it is executed. Therefore, what this means is that alteration is not valid if it is merely deliberative and when it is not final. A rebuttable presumption arises that an alteration in pencil is merely deliberative and that alteration in ink is intended, to be final. I'll refer you to Parry and then Kerridge, Laws of Succession, 12th edition, Suit and Maxwell, published in 2009, page 152, where this assertion is actually made. So what we're trying to say in essence is that an alteration that is made in a will before the will is executed, are we together, by the testator is said to be valid if the testator intends that alteration to form part of his will when it is eventually executed. Therefore, alteration will not be valid if it is merely deliberative and it is not yet to be final, because that will not form part of the will. Now, what could be considered as alteration being deliberative and not final? An alteration was said to be to be deliberative. If it is what? If it is made in pencil, and that if you make your alteration in ink, the law will presume that it is intended to be final. Therefore, the alteration made in ink would be deemed that the testator intends that the alteration should form part of the will when it is executed. If it is made in pencil, it will be deliberative, and then it will be deemed that it may be deemed that the testator may not intend that it should form part of part of the will when it is executed. Now, before I move on, let me do a summary of what we have done before so that we can all follow. I said there are times when the testator will deliberately destroy his will, or there are occasions that will arise that the destruction will be just involuntary. But our focus today is to talk about when a will is altered, when it is revived, when it is published, and various consequences that will be attaching to each of those circumstances that we are discussing this morning. I mentioned that alteration is an act done to an instrument after its execution, whereby the meaning or the language will be changed or is changed. Now, note essentially that a testator will have a change of mind sometimes before the execution of his will, with respect to, of course, to bequest that is given out in his will, or with respect to who will be the beneficiary. I also mentioned that this would necessarily bring about some changes to the will, and for such changes to be valid, the testator must make a memorandum and execute that change, alteration. Section 14 of the Wills Act, of the Wills Law of Lagos State, is similar to the provision of Section 16 of the Wills Law of Oyo State, and then they make provision for alteration in a will. Remember that I mentioned to you that the provisions of these two laws says that the obliteration, the interlineation or alteration made in a will after a will, shall be valid only if that, that alteration is actually signed by the testator and it is duly witnessed by the two witnesses. Of course, they could do that witnessing, in the margin or by the side of that alteration or at the foot of that will. If you fail to do that, it then means that your alteration will not be valid. However, we said that from that provision of Section 14 of Wills Law of Lagos State and Section 15 of Wills Law of Oyo State, what follows is that the following conclusions can be made. One, that alteration must be made before the execution of the will, where this is the case, the alteration is valid, and the section that we talked about, those sections that we talked about will not apply. Two, alterations must be duly executed. Where this is ensured, alteration will become valid. Three, and then what is sign of due execution? That is, you must execute it in the way that you have executed the original will, or that the way in which will is actually executed, whereby the executor will sign, and the testator will sign, and then the two witnesses will sign in the presence of each other to witness the will. Now, we have told you that you could do that by the margin or near where the alteration is made, or at the foot or at the bottom of the will, at the foot of the will. So we now say that the alteration is that part of the will that is not apparent, and that alteration that is made before a will is made, before a will is executed, will be valid if the executor intends that the alteration to form part of his will when it is executed. So if an alteration is made and then the testator intends that alteration to form part of his will when it is executed, then it will be a valid alteration. But note that alteration is not valid if it is merely deliberative and it is not final. If you have not made it final, that alteration is not valid. A sign that a sign that an alteration or a rebuttable presumption of an alteration is when it is said to be deliberative, in which case it could be in pencil. But when it is more or less made in in ink, when the alteration is made with ink, then it is said to be final. Now, presumption as to the time of alteration. There's also a rebuttable presumption that an unattested alteration was made after the execution of a will or any subsequent codicil. You can see, the case of Cooper and then Becket. Cooper and Becket. See, Cooper and Becket is spelled Cooper, and Becket is spelled Beckett. You can also see in the Goose of Adamson. See also in the Goose of Adamson. And see also the case of Luty and then McGill. Luty is spelled Luty, and then McGill is spelled Magil. Magil. In the Goose of Adamson, Luty and McGill, and then Cooper and Becket. Now, so the point we are saying is that, and also you can see the case of, you can see in the Goose of Hindmarsh. Hindmarsh is spelled Hindmarsh. So these cases illustrate the fact that there's a rebuttable presumption that an unattested alteration was actually made after the execution of the will, or any substitution or any subsequent codicil. Now, this presumption that we are saying here can be rebutted or has been rebutted. This presumption that unattested, the presumption that unattested alteration was made after the execution of the will has been rebutted in a number of cases. Now, I'll refer you to the case of to the goods of cards. Goods of cards. Card is spelled CADGE, card. Now, in that case, they are saying that presumption is rebutted. Where there's evidence of, where there's internal evidence within the will itself. Internal evidence within the will itself, where the alterations were made to fill blanks left in the will by the draftman. To fill the blanks left in the will, the blanks left in the will by the draftman. 2, again, where the interlineations written with the ink, where the interlineation written with the ink, as the rest of the of the will, completed the otherwise unintelligible sentences of the will. So now, in that case, they are saying that this presumption that if an alteration is unattested, it will be deemed to have been made after the execution of the will has been rebutted in situation where internal evidence has been able to show, internal evidence within the will itself has been able to show that the alterations were made to fill the blanks that were left in the will by the draftman. And again, where the interlineations written, the interlineation that is written with ink, as the rest, written in the ink, written in the ink that tallies with the ink with which the rest of the will was written, I get my mind, completed the otherwise unintelligible sentences in the will. So they are saying that this presumption that when you find an alteration in the will and then that alteration is not executed or is not signed, it then means that it was made after the will was made, after the will has been concluded. Then we are saying that this is irrebuttable. Evidence of rebuttal of that presumption is seen where they say that in that will itself, there is more or less an alteration which were made more or less to fill the blanks that are left by the draftman. So when you find that, what has happened in that will is that some blanks are actually left, by by the draftman, which was actually filled. They said it's an evidence within the will to show that this is not an alteration that was made after the will has been written or has been executed. Also, they are saying that circumstances where the interlineation is written in the same color of the ink that the rest of the will is completed. Of course, is in the same color of the ink for use in writing the will, and that interlineation is made to complete those sentences that are not intelligible ordinarily. So what we are trying to say is that there are evidence that you could adduce within the will to show that presumption that we hold here about the fact that when a will, when an alteration is not attested, then the alteration is made after the execution of will. You can. What they are saying here is that you can find evidence within the will itself to do what? To rebut that presumption. You can find evidence within the will to rebut that presumption. And two examples have been found here that they said the interlineation is written in the same ink with which the rest of the will is made, and then that interlineation was more or less completing some sentences that were otherwise unintelligible. Whereas in the first example, they are saying that the alteration that was made was more or less intended to fill the gap that was left there by the draftman. So the purpose of these two examples we are saying is that in that case, or in other cases, it's likely for us to find evidence within the will itself to do what? To rebut that presumption that when you find any alteration, that alteration is actually made after the will has been executed. So these two examples saying that it is when you see clearly that the man was more or less filling the gap that is left in the draft, that is left in the will by the draftman, or that is using the same pen, similar to the pen with which the will is written to complete sentences that would be ordinarily that would be otherwise unintelligible. You can't say that alteration is not valid. You can't say that alteration was made after the will has been executed. So now that is intrinsic evidence, that can be used to do what? To rebut that presumption that we are making here that unattested alteration was made after the execution of the will. Now there are extrinsic evidence, that is evidence outside the will that could be used to rebut that same presumption that we are talking about. Now, it could take different form. That evidence, extrinsic evidence, could take, different form to rebut this presumption that we are talking about. Now, what are those instances? Of course, evidence from the draftsman of the will, and then if you check the case of Keigwin and Keigwin is spelled Keigwin against Keigwin, that it is possible that you could get some evidence from the draftman of the will. Now, or the attesting witnesses, or the declaration made by the testator showing that he made the alterations before executing the will. So when there are evidence from the draftman, when you have evidence from the attesting witnesses, when you have evidence deduced from the declarations by the testator showing that he made those alterations before executing the will, then that presumption that any alteration that is unattested is deemed to have been made after the execution of the will be rebutted. So looking at the intrinsic evidence and extrinsic evidence, we could rebut this presumption. Intrinsic evidence has shown that when you see in a will that what the testator has done was basically to fill the blank gap, the blank that's been left in that will, or the gap that has been left in that will by the draftman, well, it could be conclusive that the alteration was done before the execution, not after the execution, or where you could see that the interlineation was done in an ink similar to the ink with which the rest of the will was written, basically to complete those sentences that otherwise would have been unintelligible. Those are intrinsic evidence that could find from the will to do what? To rebut that strong presumption that unattested alteration will be deemed to have been made after the execution of the will. Also, we are saying that extrinsic evidence, that is evidence outside the will, could also be gathered to do what? To rebut that presumption, that strong presumption. Now, that strong presumption could be rebutted by gathering evidence from the draftsman of the will, or by more or less the evidence from the attesting witnesses and the declaration that is made by the testator to show that alteration was actually made before before executing the will. You can see the case of Kegwin and Kegwin, as noted earlier. Of course, the court will consider all these internal and extrinsic evidence before deciding whether the presumption is rebutted or not. See further Kegwin and Kegwin to support that position that has been so stated. I'm not sure whether I'm making any point. Are we together? Hello?
Yes, sir.
Hello?
Yes,
Hello?
sir. We're together, sir.
We're together. So
we're together, sir. We're together, sir. Good morning, sir.
Good morning. Thank you very much. Okay, now, they said a different presumption applies if the will was made by the testator while it's privileged. You know those privileged testators. Of course, in that case, a rebuttal presumption arises that the alteration was made while the testator was still privileged, therefore entitled to make the informal alterations. Many of those category of people considered to be privileged to make will, they are not required to conform strictly with all the formalities of wills. So, and then what is being said here is that a different presumptions apply if the will was made by a testator whilst privileged, and in that case, a rebuttable presumption arises that alteration was made whilst the testator was still privileged and therefore entitled to make the informal, alteration. Look at in the goose of Tweedale. The goose of Tweedale. Tweedale is spelled TWEEDALE. So now they are saying that if you find alteration in the will of a privileged person, it will be presumed that he made that alteration while he's still privileged. That presumption that there will be a reverse presumption that he made that alteration while he's still privileged. Therefore, it will be deemed that is entitled to make that informal alteration. Now, the next point that we're going to look at is the effect of confirmation. The effect of confirmation. The effect of confirmation. Now, before I go to that effect of confirmation, I presume that we have understood what we have said from alteration made before the will, before the execution of the will, to the extent that I mentioned that the will is, if alteration is made before a will is executed, then the testator is said to be the testator is said to be is executed by that alteration made in a will before the will is executed by the testator is valid if the testator intends that the alteration should form part of the will when it is executed. Remember that also that I said that alteration is not valid if it is merely deliberative. It is deliberative if it is made in pencil, and it is final if it is made in ink. Remember that there's presumption that alteration that is not attested will be deemed to have been made after the will has been executed, and that presumption is rebuttable. That presumption is said to be capable of being rebutted in circumstances where evidence are there in the will to show that the alteration was made to fill the blanks that were left in that will by the draftman, or where the interlineations was made in the ink similar to the ink with which the rest of the will is written, with the intention of completing those statements that or sentences that would otherwise have been unintelligible. Extrinsic evidence to be gathered from the draftman or attesting witnesses or declaration by the testator showing that those alterations are more or less made before executing the will, and that court would naturally consider both the internal and the external, factors before deciding whether the presumption has been fully rebutted. Remember that we also mentioned that when an alteration is made by a privileged person, that alteration will be deemed to have been made while he's still privileged, and that he'll be entitled to make that informal alteration. Now, the effect of confirmation is the next, thing that we need to, listen attentively to understand. Now, what does it tell us? It says that where there's confirmation, by re-execution with proper formalities, it validates an alteration made in the will after it is executed, but before it is confirmed. Did you get that? It's saying that where there's a confirmation by re-execution with proper formalities, it validates an alteration made in the will after it is executed, but before it is confirmed. So what they are saying is that if a will, what this is saying is that if a will was made and it was executed, and thereafter there was an alteration that was made after the execution, and now that same will is now re-executed with proper formalities. What did that mean? What that means is that it will validate all the alteration that have been made in that will after it was executed, but before its confirmation. So now the same result follows. If after alteration is made, the will is confirmed by a duly executed codicil containing some references to the will. Two things have been said here. One, where there is a confirmation by re-execution with proper formalities, it validates an alteration made in the will after it is executed, but before it is confirmed. Now, the same result will follow if after alteration is made, the will is confirmed by a duly executed codicil containing some reference to this will. You can see in the Goose of Sky. So the summary of what I'm saying here is that if a will was executed and that there was an alteration that was not attested after the will was executed, then it then means that if there was a confirmation of that will by a re-execution with proper formalities, then it means that those alterations that were made after the execution of that will would become valid. In the same vein, if the same result will be achieved if the alteration is made and then the will is confirmed by a duly executed codicil containing some references to that will. So that is the position in the case of the good skies. So, but the alteration is not validated by confirmation of will if the alteration was merely deliberative and not final. So this alteration that we said will be validated by subsequent codicil referring to the will or confirmation, by re-execution, are we together, would not be valid if it was written in pencil, if it was not written in ink. If it was deliberative and then it was written in pencil, it will not be it will not be valid, it will not be, validated, and then it is only if it is written in ink that can be validated. So the summary of what we are saying is that a will that was made, duly executed, but was later, altered without due attestation, would that alteration made after the execution will be made valid if there's a confirmation by a re-execution. Of course, having proper formalities. That alteration which should ordinarily have been invalid will become valid. Or if there's a codicil made after that alteration to that will, after it has been executed, if that codicil is more or less referring to that will, and in that codicil is properly and is duly executed, but we are saying that those alterations that will be valid after those alterations made after the will, those alterations made to the will after the will has been executed, which will become valid by virtue of confirmation, by virtue of confirmation, or by virtue of subsequent codicil, will be such that is not deliberative, will be such that is not written in pencil, will be such that is written in pen or written in ink. Of course. So we should know that the custody must also show that the testator was treating the will as unaltered. So what we are trying to say in essence is that if this paragraph is saying that if you more or less execute a will, and then you execute a will, and then there is an alteration made after the decision of the will which is unattested, naturally that unattested alteration will be deemed to be invalid. But there's a confirmation of that will by a re-execution. By a re-execution, that re-execution will make that alteration that has been made after that will has been executed to become valid. Now, also, if there's a codicil made subsequent to that alteration that was made after the will has been executed, referring to that will, that alteration will become valid. The alteration that's not attested, made after the will has been executed, which should become valid or which should be validated, is that alteration that is not deliberative. It is not deliberative in the sense that it is not written in pencil. It is written in ink. It is final. And note that the codicil must also show that testator was treating the will as unaltered. So if the codicil that came subsequent to that is treating that will as unaltered, it then means that that alteration that was unsigned, that alteration that was not attested, made after the will has been executed, will be deemed to have been validly made, and made alteration. I'll repeat myself so that we can get the point. I'm saying that when you make, when you make a confirmation of your will or by way of re-execution in a way that is, conforming with formalities of execution under the Wills Act, and then the effect of that is that it will make valid, it will validate those alterations that were made, those alterations that were not attested, made after your will has been executed. In the same vein, if codicil is made subsequent to the alteration that is not attested after the will has been executed, and the codicil is referring to that will, and the codicil is showing that the testator is treating that will as unaltered, then it then means that the altered part of that original will, which has not been attested, would be deemed to be valid, provided that that alteration is made final, it is written in ink, it is not deliberative, it is not written in pencil. You can see Rihe to further, sharpen your knowledge about the point I am struggling to put across. Are we together? Are we together? Are we together?
Yes, sir. Yes, sir.
Okay. Now, so it's saying that unless the presumption is rebutted by evidence showing that the unattested alteration was made before the execution of the codicil, the alteration is not validated by confirmation of will by codicil. So this is more or less, recouching what we have been discussing or what we have been laboring to to put across to each other. Now, alteration that is duly executed. We now come to alteration that is duly executed. Now, what the learned author is saying here is that the alteration is executed properly with all formalities. That is where the alteration is executed properly with all formalities in view as required of the will. The alteration is then valid. So what I'm saying is that where you make an alteration to your will, either before or after the execution, either before or after the execution of the will, and then you properly execute, you properly execute, you properly carry out those formalities with regards to, alteration, then that alteration will said to be valid. I repeat myself, where the alteration is executed properly, you have executed properly with all formalities as required by the will, that alteration will said will be made to be valid. Simply put, if you make an alteration and then you sign by the margin or by the side of that will, at the bottom of that or at the foot of that will, and then your attesting witnesses also put their signature, then that means you have conformed with all the formalities that is required by the Wills Act when you are making alteration to your will, and that alteration will be deemed to be valid. Okay, now Section 21 of the Wills Act 1837, it provides that the signatures of the testator and the witnesses may be made. The signature of the testator and the witnesses may be made in the margin or some other part of the will, in the margin, some other part of the will, opposite or near to such alteration, or at the foot or the end, or opposite to the memorandum referring to such alteration, and written at the end or some part of the will. I repeat myself, Section 21 provides that the signature of the testator and the witnesses may be made in the margin or some part of the will, opposite or near such alteration. Opposite or near such alteration, your signature and the signature of the witnesses must appear opposite or near such alteration. It may be appearing in the margin. The signature of the testator and that of the witnesses may be there at the foot or the end or opposite to the end or some part of the will. What they are requiring you to do is that when your will is written and you are making alteration, you must follow those formalities regarding signature and witnessing. To that extent, we are saying that an alteration is valid if the testator signs by writing his initials in the margin against the alteration, and the testator either makes or acknowledges his signature in the simultaneous presence, of the two witnesses, who then both sign in the presence of the testator by writing their initials in the margin. See the goods of Blairwhit. In the goods of Blairwhit. Goods of Blairwhit is spelled B-L-E.
Sorry, sir, you're muted, sir.
Hello? 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 Hello?
We can hear you, sir.
I'm sorry, I was interrupted by that call. Please, I'm sorry. Okay, I don't know. Do you understand the last point that I mentioned about alteration? Hello? 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 Hello?
Yes, sir. Yes, sir. We understand.
You understand? Okay. I was a bit okay. So what this one is saying is that where the alteration is executed properly with all formalities, and then as required by the Wills Act provision, the alteration is then said to be valid. And Section 21 of the Wills Act provides that the signature of the testator and the witnesses may be made in the margin or some other part of the will opposite or near to such alteration, or at the foot or end or opposite to a memorandum referring to such alteration, and then written at the end or some part of the will. And to that extent, an alteration is said to be valid if the testator signs, by writing his initials in the margin against the alteration, and then the testator either makes or acknowledges the signature in the simultaneous presence of the two witnesses, who then both sign in the presence of the testator by writing, their initials in the margin. And I mentioned in the group of Blewitt. Blewitt is spelled Blewitt. So now, in the case of Rewhite, the testator made a will in 1981. I'm trying to read out a fact of a case to illustrate what alteration could bring about to a will. Now, the testator, made a valid will in 1981, but in 1984, he decided that he wanted to alter it. A friend made alterations to the original will in the testator's presence and at his dictation. Listen carefully. Rewhite, the testator made a valid will in 1981, but in 1984, he decided that he wanted to alter it. A friend made the alterations to the original will in the testator's presence and at his direction. Now, the alterations were initiated by the two witnesses, but the testator, who had signed the will of 1981, did not sign or initial any of the alteration that was made in 1983. The alteration could not be held valid by virtue of Section 21, and the original will was admitted to probate. You can see what happened here. The said Mr. White made a will in 1981. The will was valid. He wanted to alter it. He told his friend to do the alteration right in his presence. And then in accordance to his dictation, the alterations were initiated by two witnesses who were there present, but the testator, who had signed the will in 1981, did not sign or initial any of the alterations in 1983. The alteration was said incapable of being held valid by virtue of Section 21, and therefore the original will was still admitted to probate. I'm not sure whether I'm making any point. Am I making any points?
Yes, sir.
Okay. So there are two precautions that we need to make. Two precautions that we need to make altogether. Number one is that it is advisable to restrict alteration to the correction of small errors, such as misspelling of names, and to give effect to all other alterations by the execution of a new will or a codicil. This will reduce the likelihood that there will be a problem with construction alterations and codicil both have potential disadvantage, that someone who has lost a benefit or who has his benefit reduced will do what? Will find out what has happened. We're saying that it is advisable to restrict alterations to corrections of small errors, such as misspelling of names, and to give effect to all other alterations, by execution of a new will. The effect of this is that this reduces likelihood that there will be problem with construction, and that alteration and codicil both have the potential disadvantage that someone who has lost a benefit or who has a benefit reduced will find out, what has happened. So what I'm trying to say in essence is that the first precaution you must make when we are talking about the alteration is that, one, you must ensure that that alteration is limited to correcting some misspellings of names, minor errors. If you must make some major alteration, go and write a new will, because it will give you problem. It might give you problem in construction of that will. Two, when you make alteration, it is likely that the beneficiary who has lost a gift or who has found his benefit reduced will find out. Two, all alteration, whether made, all alteration, whenever it is made, whether before the execution or after the execution, must be duly executed. This is advisable even though the alteration is made before execution of the will, because it makes it unnecessary to rebut the presumption. It makes it what? Unnecessary to rebut the presumption that an unattested alteration was made after execution of the will. So if you immediately attest to your alteration, either made before, either made after the will has been executed or before the will has been executed, then you'll be capable, that will have helped you to rebut that presumption. In fact, you will not have to begin to rebut that presumption that all alteration made without attestation is made after the execution of the will. So part of the will not apparent is the next thing we are going to be looking at now. The alteration made after execution, which makes any part of the will not apparent, will revoke that part if the testator has an intention to revoke it. The alteration that is made after execution, which makes any part of the will not apparent, revokes that part of the will if the testator has an intention to revoke it. Probate of the will must be granted with the blank space for that part not apparent. Probate must be granted, with a blank space for the part not apparent. Okay, it should be noted that the word apparent, as used in section 21 of the will, implies visibly obvious on the face of the will. I take that again. I'm saying that the alteration made after execution, which makes any part of the will not apparent, will revoke that part of the will if the testator has an intention to revoke it. The alteration made after the execution of the will, which makes any part of the will not apparent, will revoke that part of the will if the testator has an intention to revoke it. Probate of the will must be granted with a blank space for the part not apparent. Blank space for the part not apparent. Now, we should note that the word apparent, as used in section 21 of the will, implies something that is visibly obvious. Something that is visibly obvious on the face of the will. Therefore, we need to note that a word in a will is not apparent if it cannot be deciphered, if you cannot decipher it on the face of it. So we said that apparent refers to something that is visibly obvious on the face of the will, and therefore, if a word in a will is not, a word in a will will not be apparent if we cannot decipher it from the face of it. A word will not be apparent if we are unable to decipher it from the face of it. Of course, in determining whether a word is apparent, it is not permissible. It is not permissible for us to determine whether a word is apparent to ascertain the word by the use of some extrinsic evidence. You don't use extrinsic evidence to find out if a word is apparent. Are we together? See Townley and Watson. See Townley and Watson. Townley and Watson, and then the goods of Ita. The goods of Ita. Townley and Watson and the goods of Ita to support the position that a will is not apparent if it cannot be deciphered from the face of it. And in determining whether a word is apparent or not, it is not permissible to ascertain the word by use of extrinsic evidence or physically interfering with the will by use of chemical to remove the ink, or removing a slip paper pasted over the word, or by making another document such as infrared photograph. If the word can only be ascertained by this forbidden method, it is not apparent. So what we are trying to say, in essence, is that see the case of Townley and Watson, as I mentioned here, and then in the goods of Ita. So I'm saying that the word apparent that we're talking about is referring to something that is physically obvious on the face of the will, and that is saying that a will is not apparent if it cannot be deciphered from its face, and that in determining whether a word is apparent or not, it is not permissible for us to ascertain the word by the use of some extrinsic evidence or physically interfering with it, by the use of chemicals to remove the ink, or to remove the slip that is pasted on the word, or that by making another document through infrared photograph. Because if you use any of these for the method to determine whether the document is apparent or not, then it means that the word is not apparent. Of course, the testator must make the alteration which render the part of the will not apparent with an intention to revoke that part. He must make it with intention to revoke it. A testator who accidentally obliterates part of his will by, or for example, spilling inks on it, does not therefore revoke that part of it. So they are saying that any part of your will that is not apparent and it has been altered and becomes not apparent, it must have been done with an intention to revoke that part of the will. If you do it accidentally and then your ink spill on it, then that is not revocation of the will, or that is not revocation of that part of that will. Okay, so that could be also conditional arbitration. Oh, time is not our friend. Please note where we stop here. Okay, we'll meet next week Monday, Abby. Hello?
Yes,
Hello?
sir.
Yes, sir. Yes,
Okay,
sir.
Yes.
so please, I want us to note this place. I don't want us to go back again. No. We stop at when we said that the revocation that is made by alteration must be such that he intended to have that revocation. And that's why he altered it, and the place is not, and the thing is no longer apparent. Please, let's note very importantly. I think page 460 or thereabouts of Professor Oni's textbook on succession. Okay, I'll see you then.